Many people ask, what is judicial release? Am I eligible for judicial release? Judicial release is where a common pleas judge suspends the remainder of a prison sentence and places a defendant on probation. It occurs in felony cases and can drastically reduce the amount of time someone actually spends in prison. Judicial release is not available for everyone, but only a select group of inmates. First, in order for an inmate to be eligible for judicial release, he or she must not currently be serving mandatory time. If an inmate is serving mandatory time, which usually applies in drug and sex cases, the judge will tell the defendant at the time of sentencing what portion of their sentence is mandatory. The judge may also give a defendant non-mandatory time, which is when the defendant can earn good credit and also be eligible for certain prison programming. In order for a person to be eligible for judicial release, he or she must be serving a non-mandatory sentence or be in the non-mandatory portion of a prison sentence that has both mandatory and non-mandatory time. The defendant must also make sure they are not in prison for certain offenses. Some criminal charges are not eligible for judicial release. A skilled attorney can tell you if your charge is one of those offenses. There are a number of steps to a successful judicial release motion. First, a defendant has to determine if he or she is eligible for judicial release. If the defendant is eligible for judicial release, he or she needs to file a written motion with the court. The inmate may have an attorney file the motion on their behalf or file it themselves. Traditionally, inmates who have an attorney file the motion have a better shot at it being granted. Why is this true? An experienced attorney knows the law and what the judge wants to hear before granting the motion. The lawyer will know what things that judge wants to focus on, such as the inmate's remorse for their crimes or plans upon release. A skilled lawyer will also know what programs are available for the inmate upon release and may be able to recommend that the inmate take advantage of those programs. Once the motion is filed with the clerk of courts, everyone has to wait. Sometimes the wait can be a few days. Other times, the wait can be weeks or months. If the trial judge grants a Phase 1 hearing, the court will schedule a hearing for the prosecutor and defense attorney to appear. Victims, police officers, and people supporting the inmate can also attend the hearing. The defendant does not appear at this hearing. He or she will remain incarcerated in prison unless the judge orders a Phase 2 hearing. If the judge grants a Phase 2 hearing, he or she will order the defendant back from prison. The court will schedule a hearing where the defendant, judge, and attorneys will appear. The judge will hear from everyone associated with the case. If the judge grants the Phase 2 hearing, the defendant is placed on probation. He or she may be ordered to do certain programming, such as drug treatment or a halfway house. If a defendant is successful at probation, they will have the rest of their sentence wiped out by the judge. If they are unsuccessful and violate the terms of their probation, which is usually done by picking up new criminal charges or not staying in contact with their probation officer, they can be returned to prison for the rest of their sentence. If a person is returned to prison, he or she cannot refile for judicial release and must complete the rest of their sentence. This is why defendants must be willing to take their probation seriously. One of the tricky questions people ask is, when can I file for judicial release? The answer is, it depends. The law is constantly changing about when an inmate can file for judicial release. It depends on the length of the inmate's sentence. For example, under the current law, an inmate serving a sentence of less than 2 years can file once they arrive in the prison system. Similarly, an inmate who has been sentenced to 2 to 5 years may file for judicial release after 180 days in prison. Also, a major consideration for when to file is if a judge tells you when to file. Sometimes, judges will tell defendants when they will consider a motion for judicial release. If a judge says when they will consider a motion, filing for judicial release before then can backfire. Some judges also have informal policies about when they will consider judicial release, such as not granting a motion until the defendant serves at least half of their sentence. A skilled attorney can evaluate an inmate's sentence and let the inmate and his family know when he or she is eligible to file. Attorney Adam VanHo of VanHo Law has over 2 decades of experience in courtrooms around Ohio. He has represented people in various counties and successfully argued numerous judicial release motions. Adam is a former prosecutor in Summit and Montgomery counties and was also an assistant attorney general. Adam knows what it takes to prepare a judicial release motion and how to successfully argue it. While each case is different, Adam knows that the best chance at having a judicial release motion granted is having an experienced attorney write the motion and argue it to the court. Oftentimes, Adam will begin working with a family way before the motion can be filed. This allows the family and inmate to gather all of the necessary documents and letters for the motion, as well as allows Adam to set up a telephone meeting with the inmate. If you or a loved one needs a judicial release motion filed, contact VanHo Law at 330-653-8511. That's 330-653-8511. Or check out VanHo Law on the web at VanHolaw.com. For more information about VanHo Law, which serves clients in Ohio and Pennsylvania, check us out on the web. That's VanHolaw.com.